be considered by the Social Services Committee. Those of that opinion will say aye. Contrary, no. The ayes have it. Call on Members' Order of the Day number 3.
Care of Children Law Reform Bill, first reading. Mr Speaker.
Jacinta Ardern.
Thank you, Mr Speaker. Mr Speaker, I move that the Care of Children Law Reform Bill be now read a first time. I nominate the Justice and Electoral Select Committee to consider the bill. Mr Speaker, adoption law in New Zealand was set in the 1950s. As you can imagine, at that time, the circumstances under which a biological parent sought to adopt out their child were often very different than they are today. The law was predominantly based around the idea of stranger adoption, the notion that women, often young women, may need to adopt out their child quickly and in secret to avoid what was then perceived to be the shame of a child out of wedlock, often never seeing their child again. And I want to put on record my acknowledgement of people in those situations who have shared their stories with me in light of this bill coming before the House. Children were given at that time entirely new birth certificates. A father's permission was not needed prior to an adoption order, and nor did the law stipulate that the best interest of the child were the primary consideration when considering the long-term legal relationship between a child and their future guardians. The law did not then, and does not now, cater for whāngai adoption. It has struggled to grapple with the complexity of inter-country adoption, and it certainly isn't up to date when it comes to surrogacy and new developments around assisted human reproduction. In short, Mr Speaker, our law in New Zealand is antiquated at best and certainly not fit for purpose. It is time for that to change, and I acknowledge all of those who have lobbied long and hard for that change to occur. The purpose of this bill is to carry out a complete overhaul of our adoption laws in New Zealand by making use of the work already carried out by the Law Commission over 10 years ago now. My bill will see the Law Commission update the work that they have already carried out and turn it into legislation to be tabled in Parliament for debate. I acknowledge, Mr Speaker, this is an unusual approach, but one that we on this side of the House have ultimately deemed to be a necessary one. Let me explain briefly why. The Law Commission's report, if anyone has seen it or indeed dared to read it, is Adoption and Its Alternative, a different approach and a new framework, which is what the report is titled, is an almost 350-page report. The contents page goes on, Mr Speaker, for pages and pages. It demonstrates the considerable work required to overhaul our adoption laws. While the Commission's report led to the introduction of the Care of Children Act legislation when Labour was in office, this Act did not include, at that time, adoption. Now, there are many reasons, Mr Speaker, why this work was not completed, not least the additional consultation that was required over the issue of whāngai adoption. My hope is that under this bill, this large and important piece of work will continue but will be completed. It's also important to note that since the Law Commission's first piece of work, they have also published Report 88, titled New Issues in Legal Parenthood. Many of the issues that it addresses arise in the context of adoption. And that's before, Mr Speaker, we get into the additional issues around surrogacy, and I've seen cases again there, particularly around where you get the added complexity of international surrogacy, and the issue of inter-country adoption as well. All of these are issues that do need to be included in the Law Commission's update, but ultimately need to be taken into account in our legal framework, and currently they are not, and that's leaving many families without any legal certainty and without any legal framework for providing a stable relationship for their child. I mention this because there are those who believe that modernisation of adoption simply requires the Adoption Act to be amended to modernise provisions, for instance, around just who can legally adopt children, which are inconsistent and which are out of date. But it requires much, much more than that. Our adoption laws need to be fully integrated into the Care of Children Act, which has children at the centre of all decision-making. The concept of enduring guardianship best describes the modern open adoptions that have replaced the closed stranger adoptions that were the norm in the 1950s, when our current and existing law was drafted. It makes sense that as Parliament we make use of the expertise of the Law Commission and the work that has already been done, and so doing so would be an unusual practice, though, Mr. Speaker, and I do acknowledge that. But embedding this process into a Members' Bill is, however, a very, very unique approach. But as I have said, given this work is so overdue, anything that can help us speed up reform in this area surely must be welcomed. Some have argued, Mr. Speaker, that adoption is nowadays so rarely used that reform is simply not necessary. It is true to say that last year there were fewer than 150 adoptions in New Zealand. But I would argue that we simply don't know to what degree this is a result of the fact that we have a completely antiquated legal framework that is not fit for purpose. As I have mentioned, it doesn't even cover whāngai adoption. In the past, there has also been some debate over the effect this bill would have on the inconsistent and discriminatory approach as to who can and cannot adopt. In fact, when this bill was first introduced, it completely dominated, unfortunately. The debate was solely seen to be around that one question, which is important, extremely important from an equality perspective, but is only one part of the debate. I sought permission from the Business Committee because of this element of the debate to delay the first reading of my bill until after the passing of the Marriage Definition of Marriage Amendment Bill was passed, so that there would be greater clarity around this point. And, Mr. Speaker, it is with delight that I now come back to the House with that bill now passed and able to give greater certainty to that part of the bill. The passage of the Marriage Amendment Act essentially means that same-sex couples who are married will be considered spouses under the Adoption Act and will be eligible to adopt. Ambiguity, however, remains, and this is where it gets a bit farcical for civil union couples, because there was an explicit reference during the debate around civil unions to exclude adoption for civil union couples. That leaves us with a situation, Mr. Speaker, where a married same-sex couple can adopt, but a civil union same-sex couple cannot. Where, of course, even now a de facto heterosexual couple can adopt, but a heterosexual civil union couple cannot adopt. And then you get into the farcical nature of where our laws sit in this area and why they absolutely need to be fixed. But there is the wider question, though, Mr. Speaker, of though even just fixing up the inequality that exists in the law doesn't necessarily mean that couples will want to use it because of the way it's currently shaped. Take, for instance, the situation of a same-sex couple with children. They may care for that child, but they may have an ongoing role, for instance, say, with a biological mother in that child's life. If, however, that couple wish to be recognised in legal terms in their relationship with the child and seek an adoption order, that would have the effect of severing the legal ties that child has with their other biological parent. And, Mr. Speaker, that is simply not a situation that many couples want to go down that track, and this is why I believe our adoption laws are not being fulsomely used. It has been, as I've said, unfortunate that this debate has been narrowed solely to around who can and cannot adopt. But I do want to address the issue, though, that I do believe that allowing access to adoption for all couples is a basic human right that ultimately the decision that should be made for the courts is solely whether or not the best interest of a child is being served in that decision. I want to step away from any moral arguments, Mr. Speaker, because when you put the simple fact that there are 5,000 children in New Zealand in state care who would not want the best interests of that child to be served by the most able and loving couple available to care for that child. Mr. Speaker, I know there are concerns on procedural grounds around my bill. I would ask members in this House to put those aside to give this bill a chance to go to Select Committee.
Very good. The question is that the motion be agreed to. Scott Simpson.
Mr. Speaker, the sponsor of this care of children law reform